afternoon. I would first like to request 3 minutes for rebuttal.
3 minutes?
Yes.
Okay.
May it please the court, my name is Kristen Johnson, and I am representing the appellant John Stalnaker Jr. John Stalnaker has been trying to carry out his father's wishes through multiple attempts at litigation against Carole Cupp. When he first filed his petition demanding accounting against Miss Cupp, instead of providing an answer, she filed a Rule 12.026 motion to dismiss for failure to state a claim. However, with this motion, she also attached evidence outside of the pleadings and moved for judgment on the pleadings pursuant to Rule 12.03. Because of this, Mr. Stalnaker requested an opportunity to conduct discovery, which never happened. Therefore, we argue that this decision by the trial court was procedurally improper. Rule 12.03 provides that when matters outside of the pleadings are presented to and not excluded by the court, the motion shall be treated as one for summary judgment and disposed of as provided in Rule 56. Summary judgment occurs after discovery, and discovery in this case never happened. This failure to exclude evidence confused the issues and the procedural posture of this case. Petitioner then, in his response to this motion to dismiss and motion for judgment on the pleadings, he made arguments related to this extraneous evidence, such as giving context to previous correspondence. There was additional evidence related to the trust that in his response he states he has never seen until it was attached to this motion. And just as an anecdote, we had a case in Davidson County Chancery Court where this very thing happened. As the defendant, we filed a motion to dismiss, and the plaintiff responded and moved for judgment on the pleadings. In that case, the trial court first held that moving for judgment on the pleadings was procedurally improper at the motion to dismiss stage. And then the judge cited to Teaster versus Tennessee Department of Correction to state that it's important for trial courts to give formal notice whether they will consider extraneous factors or not. This eliminates the confusion and misunderstandings around the posture of proceedings. And it's our position that that should have been done here in this case. The court never gave formal notice of what the procedural posture of the case was, whether it was going to consider these extraneous factors or not. Additionally, it is our position that fraudulent concealment told Mr. Stalnaker's conversion claim. The trial court's order acknowledges that fraudulent concealment could toll his claims, but it focused on inquiry notice and whether he conducted reasonable diligence to establish fraudulent concealment. He had a stroke in 2014, and we do acknowledge that the mental incapacity was outside of what we would argue for tolling the statute of limitations. However, it's unclear exactly when this fraudulent concealment occurred leading up to the stroke.
So you're on appeal, you're not relying on mental incapacity?
We are not, Your Honor. We are focusing on making a good faith argument for the fraudulent concealment aspect. However, I would argue that the mental incapacity does play a role here for fraudulent concealment, because there were many years that had lapsed at issue here, and part of that reasonable diligence on his part was there were many years where he was incapacitated due to his stroke, and he simply did not know what was happening at the time.
But his stroke occurred several years after his father died, for example.
Yes,
like
yes, Your
5
Honor.
years or something.
Yes, Your Honor.
And he didn't receive anything. Shouldn't he have been on some sort of inquiry notice during that time that something was up?
Yes, Your Honor. Our position is that we simply don't know what happened, and so that's all the reason why they should have proceeded to conduct discovery. And ultimately drawing a reasonable inference in favor of the petitioner does support fraudulent concealment. I would also like to point out that the respondent's first argument in response to this petition is to state that she never acted as a trustee or co-trustee of this trust. However, the trial court found that not to be true. In page 10 of the order, it states it is uncontested that the respondent was appointed as co-trustee of the MCT. So first of all, the pleadings before the trial court at least show some inconsistencies in her representations in litigation. Second of all, the language of the order reads more like what you would find in an order on summary judgment, where you state it's uncontested that this is a fact at issue here.
The conversion claim you mentioned has a 3-year statute of limitations.
Yes, Your Honor.
The stepmother's estate was fully administered in May of 2011.
Yes, Your Honor.
Your client did not have a stroke until July of 2014.
Yes.
So, how does fraudulent concealment save that claim?
So between the years of 2011 and 2014, we're arguing that fraudulent concealment applied, and I will state that we don't have the specifics of what happened, and that is the very reason why he's trying to conduct discovery to find out what happened during this time. And the petition states that
during the time between the closing of the stepmother's estate and the stroke,
yes.
you don't know what happened?
Yes, Your Honor.
But if the stepmother had engaged in fraudulent concealment, surely it would have been done, before she died and before her estate was done.
This is a claim against the stepmother's sister.
This is a claim against Ms. Cupp.
Yes.
So you're not proceeding against
No,
the
this is
stepmother, even though it was alleged, as I understood it, she took part in it?
Well, that is another point that did come up in the response, or in the motion to dismiss. There was evidence related to what the stepmother did under the trust, and his response was he had never seen this evidence before.
No.
So this...
Why had he never seen it?
Well, this is why exactly we're requesting for discovery to be taken, and it does confuse whether this was a motion to dismiss. Are we just sticking to what was in the petition, or is this a judgment on the pleadings? And therefore, there should have been some discovery, and all that Mr. Stalnaker has been looking for this whole time is to find out what happened. So it is our position that first, it is Mr. Stalnaker's belief that she did fraudulently convert these funds, and he simply wants to find out what happened, and therefore this court should allow his conversion claim to proceed. Thank you. Against Ms. Cupp. Yes, because she...
There's nothing against the stepmother now?
No, this is a claim against...
This is all against Ms. Cupp for post-2011 actions?
Yes. Yes,
Okay.
Your Honor. Because of her status as trustee.
Counsel, if we're building a list of what you view as being improperly considered by the trial court, what's on it? What all was improperly considered here?
Your Honor, that is a good question, and it is simply unclear. I do understand that the court may take judicial notice that California litigation did occur before this. However, there were things that were brought up in this motion to dismiss that are letters, correspondence, and, like I mentioned, evidence related to the trust. I know that was Exhibit D in this motion to dismiss.
Well, but one of the letters that was considered was attached to the petition, was it not?
Yes, there was a letter demanding an accounting. The letter that I'm referring to is correspondence from a California attorney, and where he's referring to Ms. Cupp as a trustee. And this is all the way back in 2002. However, in Ms. Cupp's response, she alleges she was never a trustee. So it just simply confused the issues and the procedural posture of the case, and what we are seeking is, at least for this conversion claim, which has a 3-year statute of limitations, to proceed, and for discovery to be conducted to find out what happened.
Well, you're saying conversion plus breach of contract, right?
We are, for purposes of appeal, we are only making an argument for the conversion claim.
Oh, only on the conversion, okay, thank you.
Yes. Thank you.
Good afternoon. I am Pat Young and represent Carole Cupp. The court's order made clear that she dismissed the suit for failure to state a claim, cause of action on which relief can be granted. She did, I think it was obvious, and this is appellate counsel, they were not at the hearing. The one item mentioned outside of the petition was a California lawsuit that was filed in September of 2020 and dismissed by the California court for lack of jurisdiction in January of 21. That's not what her ruling was based on. It was simply mentioned. And I think she had the right to take judicial notice that a prior suit had been filed on substantially the same grounds. But John Stalnaker Sr. and his wife Mary created a trust in 1981 that was called the Trust Number 1 throughout. It had Exhibit A, which was the community property of the two parties, the husband and wife, and then Exhibit B was their separate property, except there were no exhibits on that, none attached to the trust. Attached to the petition is Exhibit 1. The third amendment to the Number 1 trust had Exhibit or Schedule A, but it was blank, but signed by both parties, John and Mary. Exhibit B, their separate property, had a little statement, a blurb at the top typed about the following property. It is thereafter blank, and both parties signed it. So we don't know what was ever in that trust. Through several amendments, trustees were changed, and we never said Mrs. Cupp was not appointed. We said she never served. She was never called upon to serve. So after that trust was created, at the death of the first spouse, there were to be two new trusts created, a survivor spouse and what was called the residual trust that in, I think, Amendment 2 or 3 became the maximum credit trust. And that was the deceased spouse trust versus the survivor's trust. The survivor's trust is not an exhibit to the petition. The marital credit trust is not an exhibit to the petition. They've never been produced. They were not produced with the petition, the only filing in this lawsuit other than the motion to dismiss. So again, we don't know what was in the trust. We don't know if there was a survivor's trust and a marital credit trust, or what was in them. So when you want to jump to conversion of what? There is nothing to identify to say that Mrs. Cupp or her sister or anyone since John's death in 2000, he died in November of 2000, 13 years before his son's stroke. Mary ended up in Tennessee and died here in 2009. The court entered an order that's attached to the petition saying the estate was properly administered, no claims had been filed, and closed that. That was, as the courts pointed out, the statute, the 3-year statute would have expired before his stroke in July of 2014. Mr. Stalnaker says that until February of 2020, the stroke interfered with his ability to understand the trust and the maximum credit trust. He doesn't really mention the survivor's trust, that would have been Mary's. And then he wrote a letter, the March 12 demand letter, saying, you owe me an accounting and I might sue you for breach of your fiduciary duty if you don't give me this accounting of all these things.
So we never knew what was in. Would you repeat which trust we never knew?
The original trust, the 1981 trust had Schedule A and B. A
Yes.
was marital community property, and B was each of the
What about
spouses separate.
the two trusts that followed after that?
Neither are attached to the petition.
So we don't know what was in those either.
We don't know if they were created. There's an allegation they were created based on the terms of the trust, but they are not produced, they don't exist, and there are no definition of assets in those.
And You're saying your client's position is that she never served as trustee?
Well, she might have been named in a document.
But she never served as trustee?
Yeah, I mean, and then when Mary came here, in 2009, after her husband died in 2000, I'm sorry, he died in 2000, she came in 2009, years later. But all of this was well before Mr. Stalnaker Jr. had his stroke. There's exhibits from the probate court in Mr. Stalnaker's estate. He was aware his father died. Surely, if he was concerned about what he should have gotten, he would have done something before 2020, writing letters to his stepmother's sister. But the court went through each item without regard to any additional proof, anything outside the petition, just looking at the dates and the time, and decided that, one, there's no contract between Ms. Cupp and Mr. Stalnaker Jr. No contract whatsoever.
But Ms. Cupp did serve as executrix
Of her sister's estate.
Her sister's estate.
Yes,
Yeah,
sir.
Okay.
That was probated in Williamson County. After the March 12, 2020 letter saying, I need an accounting or I'm going to consider filing suit against you for breach of fiduciary duties, specifically naming breach of fiduciary duties, he filed suit in Tennessee in September of 2022. The 2020 and 21 dismissal of the California suit is really irrelevant, doesn't change any of the dates for our statute of limitation. And the court methodically went through the statute and the facts alleged in the petition and why they did or did not apply or change it. She did not believe the statute was told for fraud because there were years before the debilitating stroke that those statutes would not be applicable to tolling the 1-year statute for suit against a fiduciary of a trust. And we submit that the court made a very well thought out, well reasoned, and explained her ruling throughout the order. And I go back to the purpose of a statute of limitations, as this court well knows. Problems develop when decades go by before suits are brought. It's to protect defendants from unfair legal action. Evidence is lost or obscured or not retrievable, like the marital credit trust and the survivor's trust. We don't know what was in the original trust. So I don't know how you have discovery about something without a starting point of this document was violated in this manner. You can't convert over speculated damages. The court can't determine what might have been in the trust. Mr. Stalnaker Jr. should have been involved in his father's probate estate. And after that, I don't know what would have happened. If he kept in touch with his stepmother, if he didn't, if he was aware of these trusts, if he wasn't. That is all ancient history from 1981 to 2000 when his father died. But to come in here in 2022 and say, I'm going to bring you into this massive litigation to determine what you may or may not have done and what your sister may or may not have done regarding the trust my father may or may not have had created after his death, or was created for him.
Well, as I understood it, Ms. Johnson says they are pursuing only the conversion claim here. And it's your position that before his stroke, he had plenty of time to investigate all that, and the statute of limitations had run.
Yes, sir.
When would the statute of limitations have started?
I would say after his father's death. If there was a conversion, it had to have occurred at some point after his father's death. And the only way I think one could prove that is to know what his probate estate consisted of and whether there was a trust involved, separate or outside that probate estate.
So when you don't know what the state consists of, that's sort of when you need to start investigating.
As the son of a decedent,
Yeah.
with a,
Okay.
married to a woman that's not my mother, I think I would start asking questions if I was concerned.
But the trust that's in the record does have provision for creation of additional trust.
Yes,
Okay.
it actually has a directive that on the death of the first spouse, to the survivors and what became the maximum credit trust would be created, and that the decedents and the survivors' share of the community property would be in the survivors' trust or the maximum credit trust, and that spouse's separate property.
But we don't know what's in anything.
No, sir.
Okay.
Thank you.
Thank you.
I'll just address a couple points. First, she did say that she was never appointed, and that is in volume 1, page 106 of the record. The very reason why we do not know what was in the trust is why Mr. Stalnaker seeks this discovery. So it is a little bit of a catch-22, but that is the whole reason why he is seeking this litigation against her. He has his belief, and he has various reasons to believe why there was funds in the trust that was converted, but he doesn't know what it was, and so that's why.
And so what allegations in your petition do we look at to look for the facts for the fraudulent concealment here? And particularly I'm interested in what allegations set forth the dates of that concealment, because it seems to me that's really important here, given the length of time that has elapsed since Mary's estate is closed.
Yes, Your Honor, and I would first like to point to the fact that we know she had a duty that she failed to perform. She had a duty to provide notice to him, and she did not do that, and the trial court held as such. As for anything else specifically, he's in California, and the relationship, I don't know the status of the relationship between the stepmother and the stepmother's sister, but it does appear that he just simply did not know after the stepmother's death what was going on here in Tennessee. So,
And shouldn't he have initiated something then to find out what was going on?
we would argue that at this motion to dismiss stage, the reasonable inferences should have been construed in favor of him. Thank you.
Thank you very much. Thank you both. I believe that concludes today's docket. Would you please dismiss court?